So, moving into ahead in, in the topic of standard form of contract, today I will discuss with you the landmark case of standard form of contract, that is Central Inland Water Transport Corporation Limited versus Bosonath Gongli 1986. So the fact of case are as follows. The respondent Bursanath Kongli was working in Navigation Company Limited. The company was taken over in 1967 by appellant, that is Central Inland Water Transport Limited Corporation, Government Corporation. The letter of appointment given by the corporation provided that Bursanath Gongli would be subject to service rules of the corporation and he had to follow the some rules laid down by the corporation. So rule 91 of the Central Inland Water Transport Corporation Limited Service Discipline and Appeal Rules of 1979 provided that a permanent employee can be terminated just by 3 months notice or pay in lieu of notice without assigning any reason. So when Burjanath Gangli was fired from his job, he filed a suit, and the lower court passed the judgment in his favor. But the appellant corporation appealed in the Supreme Court, and he argued that there was nothing unconscionable about Rule 9(1) and it was necessary for proper functioning of the administration of corporation. Respondent argued that Rule 1 is unconscionable because it was very harsh and both the parties are not have equality in bargaining power. In his judgment, the court said that unconscionability has not been defined anywhere in Indian Contract Act 1872. The word unconscionable is only used in 16.3, that is undue influence, making contract voidable in Indian Contract Act 1872. So the unconscionability is defined in Shorter Oxford English Dictionary, which says showing no regard for conscience, irreconcilable with what is right and reasonable, is termed as unconscionable. So the constitution was enacted to secure all citizens of the country social, economic and political justice. Article 14 of the constitution guarantees to all persons equality before law and equal protection of law. This principle strikes down an unfair and unconscionable contract or an unfair and unreasonable clause in a contract entered into between parties who are equal in bargaining power. So there are many contentions raised in this case. That is, one of them is why we are making the contract void, not voidable. Discussing this, the court held that such contracts are rarely induced by undue influence as defined by section 16 of the Indian Contract Act, even though at times they are between parties one of whom holds a real or apparent authority over the other. Such contract which affects a large number of person or a group of person, if they are unconscionable, unfair and unreasonable, are injurious to public interest. To say that such a contract is only voidable would be to compel each person with whom the party with superior bargaining power had contracted to go to court to have the contract adjudged voidable. This would result in multiplicity of litigation, which no court should encourage and would not be in public interest. So, such a contract or such a clause in a contract ought therefore to be adjudged void. In order that such contract should be void, it must fall with under Section 23 of the Indian Contract Act 1872, which states that consideration or object of an agreement is unlawful unless the court regards it as opposed to public policy. And discussing the public policy in this case raised by the appellant, that it is not against the appellant contention that it is not against the public policy. So court held that the Indian Contract Act does not define the expression public policy or opposed to public policy. Public policy, however, is not the public of a policy of a particular government. It cannot some matter which concern the public good and public interest. This concept is varied from time to time, and a judge can expound his judgment, not expand. Only he can draw analogy which is precedent given to him, not add a new head in public policy or give his opinion. The only situation became very harsh, then only he can add a new head in public policy. The court held that clause such as clause 1 of rule 9 is against right and reasonable. It is wholly unconscionable. It has been entered into between parties between whom there is gross inequality of bargaining power. Keep that point in mind, that gross inequality of bargaining power. And said corporation can find hundred of other to take the officer's place, but officer cannot afford to lose his job because no hundred job is waiting for him. And so rule line 1 is a term of contract between the corporation and all the officers. It affects a large number of persons. It is harmful and injurious to public interest. Such a clause therefore opposed to public policy, and being opposed to public policy, it is void under section 23 of the Indian Contract Act. So this, I think this much is suffice for the standard form of contract. Thank you so much for watching this video. If you like this video, then please share it and subscribe my channel, and do click on bell icon. Thank you so much.